student loans are very, very tough to discharge in bankruptcy because you have to show hardship. And in the 11th Circuit, which is Alabama, Georgia, and Florida, you have the Brunner test, which looks at past, present, and future ability to repay those loans. And it's a very, very tough test to overcome.
Is that throughout the state of Florida or just in our district?
It's on the 3 states, really, Georgia, Alabama, and Florida, and I might say most of the United States, most of the circuits have adopted the Brunner test.
And so any likelihood of that changing down the road?
Only if the 11th Circuit acts and overturns the Brunner test, and I don't see that on the horizon.
Well, by the way, the reason that student loans are not dischargeable in bankruptcy is a combination of both state and federal law. Our federal Congress could change the law and make student loans dischargeable.
Yes, and they have. It's under 523A8, I believe. And they have changed that law a few times. There was a time when student loans were dischargeable after a certain time period. And then, of course, they have changed them again and again. Right now, it basically just says that you have to show a hardship. So that hardship, unfortunately, is defined by case law, and the case law is very tough. So I wouldn't count upon Congress changing it. I would look to see whether or not the circuits begin to disagree with the harshness of that test.
So the federal law defines it as hardship to discharge student loans.
That's right. That's what you have to show.
The courts are the ones who are defining hardship.
That's right. They're the ones who set up the tests for determining what is a hardship and what is not.
Well, if I say that bankruptcy is a combination of both state and federal law, could Florida in its own government discharge bankruptcy or student debts in bankruptcy?
No. In bankruptcy, of course, you're filing in a federal court, and we do use from time to time state law to define terms under the bankruptcy code, but student loans, of course, are federal in nature, and the 11th Circuit has set up that test. Now, for things like contracts and mortgages, if we want to interpret some sort of specific aspect of that, we do look to state law.